comes. Ready? I call this meeting of the House and Children Family Affairs Subcommittee to order. Welcome, everyone. Haley, would you please call the roll?
Representatives Bricken. Here. Carter. Eldridge. Here. Gillespie.
Here.
Harris.
Here.
Stewart.
Here.
Chairman Littleton.
Here.
Madam Chair, you have a quorum.
Thank you, Haley. We're going to get right into business. We have a few items that have been taken off notice, and some have been rolled a week or two, so we're going to go over those. Item number one, House Bill 1588 by Leader Camper has been rolled to the first calendar of 2022. Number three, by Representative Hodges of House Bill 450, has been taken off notice. Number four, House Bill 1377 by Chairman Crawford has been rolled 1 week per sponsor request. Number seven, House Bill 1079 by Chairman Sexton has been rolled 1 week per sponsor request. So after all that, is there any personal request? Here none. Well, are we ready? Well, let's call up number two by Representative or Chairman Farmer. Representative Lowell. House Bill 1126.
Thank you,
Properly
Madam.
motion and second. You're recognized.
Thank you, Madam Chairman. House Bill 1126 defines the term seclusion as it relates to juvenile detention centers, youth development centers, and facilities where children are taken into custody prior to or after court rulings. The bill will fix a loophole that allowed juveniles to be placed in segregated, confined settings for an extended period of time. It was not considered seclusion under the current law because they could hear and see others. The bill further clarifies that seclusion is not to be used for any reason other than temporary response to behavior that threatens immediate harm to others.
Okay. And I see that you do have an amendment.
Yeah, let me find it. I believe I do. 5436.
That is right. Do I hear a motion? Second on the properly motion and second. 4536.
Yes, Madam Chairman.
Would you like to describe that?
It makes the bill pretty much, make sure I got that right. I just picked this up 2 days ago.
That's all right.
But it makes the bill.
Do I hear a second on the amendment? All those in favor of putting Amendment 4536 on to House Bill 1126, say aye. Aye. Those opposed, no. You're recognized on 1126 as amended.
I renew my motion.
Are there any questions? Questions been called for? Any objection? Are we ready to vote? All those in favor of House Bill 1126, say aye. Aye. Those opposed, no. Ayes have it. You move out to civil full.
Thank you.
Thank you. Number three is off notice, and number four has been rolled. Number five is House Bill 1104 by Representative Shaw. Motion. Second. Properly motioned and second. Representative Shaw, you're recognized.
Thank you, Madam Chair and members. First of all, let me say that I realize this bill has a small fiscal note on it, but what I want to do is, if possible, if this committee will allow me to, is to move it to finance and work with the fiscal note at that particular time. But what it really does, it establishes a responsible fatherhood commission for the purpose of studying issues that jeopardizes the father-childhood bond and defined objective ways that fathers can better serve children. This is something that I picked up from a bill that past legislator John DeBerry had here once before, and we did not move it all the way through, but we think that this time we can move it through. And what the fiscal note would do would pay for establishing that committee to look out for private funds and private donations to actually fund this as we go along. So with the permission, Lady Chair, of you and the commission, if we could move it to finance where I could deal with that small fiscal note, I really would appreciate it. And with that, I would be willing to answer any questions you may have.
So I see that in 2002, there was a commission just like this one that you're creating now. Is that correct?
Yes, ma'am.
And
That's
what-
correct.
And what came out of that study?
I don't have all of the details, to be totally honest with you. I picked this up. I don't know exactly where it got to, but from what I've been told, we could perhaps complete it if we could get this fiscal note and get it up to the right place. So that's really why I'm here at the mercy of this committee to ask if we could move it to see if we could do that, because finance will either kill it or it will move on.
So I guess my question is, why did it not complete? What happened there? What were the results of that
I
commission?
think the results, to my knowledge, the best I can speak to it, is that someone just didn't proceed to follow along with it. You know, sometimes here you start things and it don't, but I believe we got the administration's back and then everybody else to follow through with it if we could get it to the right place. And that's the best answer I can give you now. I can do some research, try to find out more in the next committee if I could move it to that.
Well, I'd definitely like to hear more about it, that's for sure. So,
Thank you.
are there any other questions? Vice Chair Brickman, you're recognized.
Again, I think the concept probably has merit, but I agree with our chair lady that before it comes out of this committee, I think we should have a better history of the previous commission and what we were trying to do here, because I certainly just philosophical hate creating commissions for commission's sake, and if the last one didn't have legs and move forward, then there's a good chance this one might not. If we're going to meet, this is not our final calendar, is it?
No.
Would the sponsor consider rolling this 1 week so we can hear more about what happened to the previous commission?
I would certainly be at the will of this committee. Yes, sir.
Was that a motion, Vice Chair Brickman?
I make a motion to roll for 1 week and hear back on what happened to the previous commission.
Second.
Properly motion and second. All those in favor of a week roll for Representative Shaw, say aye. Those opposed, no. The ayes have it. So it's rolled 1 week.
Thank you, Madam Chair. And I just got a text from Representative Holloway, said to tell you that he's having car issues and that's why he's late.
Okay, thank you.
Thank you, and thank you, committee. Thank you for your time.
So next we have item number 6, House Bill 581 by Chairman Reagan. I don't see him, so we will move him to the Hill. 1079, item number 7 has been rolled 1 week. So next we have number 8, House Bill 466 by Representative McKenzie.
Second.
Properly motioned and second. You're recognized.
Thank you, Madam Chair Lady. House Bill 466 was written, I'm sorry, there's an amendment coded 6131.
Would like to describe your
Yes,
amendment, please?
that makes the bill.
Do we hear a motion second on this amendment? Properly motion and second. You want to vote, let's vote to put the amendment on without objection. All those in favor of amendment 6131, say aye. Those opposed, no. The ayes have it.
Thank you, Madam Chair.
You're recognized on 466 as amended.
Thank you. House Bill 466 as amended was written to help address the financial burden on relative caregivers that are awarded custody or guardianship of minor family members. As you all know, if a child is taken and placed in foster care, that family receives all kinds of assistance ranging from monthly support payments, healthcare coverage, daycare stipends. And you know, we see far too often when we go to our Walmarts and Targets that we have minors that are staying with grandparents, with aunts, with uncles. And so, but what happens with that, they get no financial assistance. So what this bill is asking is that we have a 3-year pilot that kicks in, that gives that relative caregiver half of the assistance of that monthly stipend amount that we give to the foster parents. We just feel that it's best to be in a culture of familiarity, and those relative caregivers are a crucial key in that child's raising.
Are there any questions for Representative McKenzie? Vice Chair Brigham, you recognize.
Thank you, Chair Lady. How is,
You're recognized.
Yes, we spoke with the folks at DCS, and they actually worked with a lot of the language, myself and the Senate sponsor, and I don't have it written out, so I don't want to put words in their mouth. I'm pretty sure they are returning on this one. But they actually helped write the amendment to make it palatable to them.
well, that's fine. That's all.
Well, I think my only concern is that giant fiscal note. I agree with your intent here, but with a giant fiscal note like that, I don't see that going anywhere.
Well, I guess I will say that, you know, I'm sure Finance, Ways and Means will have to take that up, but I just feel that it's an extremely, you know, I spoke with a lady, Inger Green out of my district that has 3 of her children, and it's just, you know, as I said, kids keep growing, they keep eating, they keep, shoe sizes get larger and larger, so I think this is worth the ask, and it's vitally important.
And again, I do agree with that, but I still think with that fiscal note, I'm not sure that it can go anywhere. So,
I think this thank you, Madam Chair Lady. I mean, this bill, again, the concept probably has a lot of merit. I'm sure there are children that are in desperate need for this. How DCS will qualify them and administrate this in such a way as those children maybe come in and out of households. It just seems, well, I certainly would like to hear from DCS before I vote on this bill, but so I just have some difficulty with it. I certainly think it needs to be studied more. Honestly, I certainly would like to see it go to summer study, and then we can bring it back next year once we hear more about it. So I'm going to make a motion to move this bill to summer study.
If I could ask a question of the sponsor of this motion.
Sure.
And I just wonder, it might be easier, I'm not trying to say what, I wonder if we could just maybe give the sponsor a chance to roll his bill to the 1st of next year, achieve the same effect, but that way we don't have a formal summer study. He could just move it till the first calendar of next year, and then it'll be sitting there, and we'll either have what you want or not. What would you think about that?
I would accept that.
That might be, I leave it to the sponsor to decide if he'd like to do that.
I make a motion to move this a bill to the first calendar of next year. Sure.
Okay, thank you. I think the fact that it has a physical note on it like it does tells us that there is a serious problem there that does bear to be looked at. I know people that are in those situations with raising their grandchildren. And I even know of one case where they're raising their great-grandchild. And financially, they struggle quite a bit. They have to look to central services for help with clothes and oftentimes food. So the fact that that physical note is where it's at, I think bears that, that we do take a good look at it. I'm in agreement with the role, but that's my only comment.
Representative Bricken,
Pardon?
do you want to go through with your motion? Or
Yes, I do.
You want to?
Roll it to the first available calendar
Instead of
next
studying it?
year.
Okay. Then maybe we could study it over the summer with all of us, but I agree with you where if there's that big of a fiscal note, there's definitely a problem there. You're recognized.
Thank you. And thank you for that. That was actually a point that I want to make. And it gets to the members' statement in that if you look at what the percentage of Tennesseans that are in that official category as a relative caregiver, our percentage is a lot smaller. So I do think it's indicative of an issue, and I don't think it's a funding issue. And I really think, on the back end of things, we'll be in a much better situation if we have more relative caregivers. But I definitely understand what you all are saying, and I will be
So we're going to
amenable.
move this to the first calendar of 2022. Thank you. Without objection.
Thank you, ma'am.
So next is item number 9, House Bill 1292 by Representative Johnson.
Thank you, Madam Chair and members.
I don't think you have a motion yet. I don't hear a second either.
Can I roll it to the end?
You can.
Thank you.
To the end of,
Today's.
sure. To the hill of today's calendar. Yes. Next up is item number 10, House Bill 1190 by Representative Garrett.
Motion. Second.
Properly motioned and second. You are recognized.
Thank you, Madam Chair and committee. This legislation that's before you today was brought to me by the Tennessee Bar Association. What it does, it discusses when property is held in a trust, that right now we do not have a mechanism in our statute that says that trust vests in the trustee. The reason why that's important is because the trust can be named something completely different than it is the trustee, so the registrar's office has a hard time finding title in the chain of title search. So we got to make sure we name it properly, and when real property is put into a trust, it's actually vested in the trustee. So with that, Madam Chair, I'll be happy to answer any questions the committee may have.
Any questions? Representative Harris, you're recognized.
Thank you so much for bringing this. I actually work for the trustee, and so this is a good bill.
Hopefully it'll make your job a little easier. Thank you very much for that.
Any other questions? Hearing none, are we ready to vote? All those in favor of House Bill 1190 moving out to civil pool, say aye. Those opposed, no. Ayes have it.
Thank you, Madam Chair and
It was
committee.
less than 5 minutes. Good job.
I'm working on it.
Yeah.
You're working on it.
Thank you. And we're going to go out of session and turn the gavel over to Vice Chair Brickham.
Going to get the mic going. I think we're back in session there. We have House Bill 237 by Chairman Littleton. Second. Got a motion and second. The bill does have an amendment that right, Madam Chairman?
Yes, Chairman, it's 5210 that makes the bill.
That is correct. All right, motion and a second on the, we have it? Very good. All right, you want to discuss the amendment, or want me to put it on the bill? And
Could we
then,
put the amendment on first, please?
all right, any objections? All in favor of putting Amendment 5210 on House Bill 237, say aye. Aye. Any opposed? All right, it's on the bill. All right, Madam Chairman.
First, this bill would make clear that it is the public policy of the state to order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of a child, consistent with the factors specified in the present law and pursuant to the present law, which considers the child's best interest. Second, the legislation would specify that orders of custody arrangements must include written findings of fact and conclusions of law to support the basis for the order in cases where both parents have not agreed to a custody agreement and parenting plan. Third, under this existing kinship foster care program, this bill would add that when a child has been removed from the home, one parent, as in the care, custody, or guardianship of the department must consider to evaluate the child's other natural or adoptive parent, if available, for placement before considering any other relative pursuant to present law.
Thank you for that explanation. Any questions on the bill? Seeing none, I call the bill. All in favor, say aye.
Aye.
Any opposed? The bill passes. It moves on to Civil Justice Full Committee.
Thank you, Mr. Chairman and Committee.
All right. Next, Chairman Littleton, is House Bill 467. I think it has an amendment.
Yes, sir. It does. It's 6244. And it
Amendment
does make the bill.
6244, that makes the bill. Have a motion and a second?
Second.
All right, motion has been properly motioned. Let's go ahead and vote and put the amendment on the bill. All in favor, say aye.
Aye.
Any opposed? The amendment's on the bill. So now, Madam Chairman, would you like to explain your bill? Oh. Do we have a motion and second on the bill as amended? All right, Mayor, it's properly motioned and seconded. So, Mayor, Madam Chairman, would you like to report on the bill?
I would. When testing, this come from the DAs for testing children that have been drug exposed. When testing a child for the presence of a controlled substance in the child's body, the department shall use hair follicle, and the department may also use any other testing method in addition to the hair follicle test. The DAs think it's easier to prosecute if they have a hair follicle, but we wanted to allow them to be able to use the urine samples and other nails and things like that as well.
Any questions to the chairman about House Bill 465? Hearing none, I'll call the question. All in favor of passing House Bill 465 to Civil Justice Full Committee, say aye. Aye. Any opposed? Hearing none, the bill passes, so 465 moves on to full civil. Next, item 13 is House Bill 1231 by Chairman Littleton. Do we have a motion and second? Motion. Okay. We have a motion and second. It has an amendment with it. Motion on the amendment. Second. And a motion and second. It's Amendment 5506.
That's correct, but it doesn't make the bill.
It
does not make the bill.
Okay. So would you just like to discuss the amendment?
It adds to the youth development centers and other hardware secure facilities to contact DCS to the facilities affected to the requirements to specify that in order for the OFSI to be charged with a Class C felony offense, the failure to comply with the reporting requirements must have been intentional.
Any questions to the chairman about the amendment 5506? Hearing none. All in favor of putting amendment 5506 on House Bill 1231, signify by saying aye. Aye. Any opposed? The amendment is on the bill. Would you like to talk about the bill anymore?
I would just a little. This is to kind of put a little bit of a charge to, remember a few years ago in Nashville, we had some escapees at the juvenile detention center, and instead of calling the police, they went out themselves hunting the escapees. So they were on the run for a few hours, maybe even a couple of days before they found them. So this is just saying that if they do this intentional and they do not notify the proper authorities intentionally, that it could be a Class C felony.
Any questions to the chairman on the bill as amended? Representative Gillespie.
Thank you, Mr. Chairman. I'm completely supportive of the bill. I'm just curious. Is it the person, the administrator of the facility that would get charged? The person that did not take action? I was just curious, and we can talk about this later, but.
Madam?
It would be the attendees that are in charge at the time.
Thank you.
Any further questions on the bill? Seeing none, we're going to be voting on House Bill 1231 as amended. All signify positive by saying aye.
Aye.
Any opposed? Hearing none. House Bill 1231 as amended moves on to Civil Justice Full Committee. And with that, I will gavel back out and pass it on.
Thank you, Vice Chair Brickham. We are now back in session. I see that Chairman Reagan has come in. You are recognized on item number 6, House Bill 581. Do we have a motion? Second? Second. Properly motioned and second, you're recognized. And I see that you do have an amendment.
Yes, ma'am. The amendment code is 5451.
That's correct. Does it
And
make the
it
bill?
does not rewrite the bill.
Okay,
It
then-
does rewrite a section of
So
the
do you
bill.
want to talk about that and let us put it on after?
It makes more sense to talk about the bill in its entirety. This is not a substantive change to what,
Okay. Do I hear a second on the amendment? Second. All those in favor of putting the amendment on House Bill 581, say aye. Those opposed, no. The ayes have it. You are on House Bill 581 as amended.
Thank you, Madam Chair. This bill is brought to me by the Clerk Courts Association, which is COAT. I don't know what that means, but anyway, it creates an additional avenue for notifying the next of kin of conservatorship proceedings, whereas now the current law only allows the next of kin to be notified by certified mail. This is an issue for the next of kin whose whereabouts are unknown, as well as an issue where the U.S. Postal Service cannot or will not deliver certified mail due to extraordinary circumstances, such as natural disasters or pandemics. This alleviates a situation where no address can be found for the next of kin. It clarifies that medical records attached to a petition for conservatorship are confidential, whereas now the law gives the impression that the burden is on the potentially disabled person to request their medical records be sealed by the court. This law does not require them to do that. And it clarifies that a petitioner is responsible for the cost of publication if it's applicable. With that explanation, I stand ready to answer questions. And as far as the amendment that was put on, I will address that very briefly. It just limits the ability of people to get this information except where authorized by law.
Thank you. Are there any questions or concerns for Chairman Reagan? Hearing none, are we ready to vote? All those in favor of House Bill 1079, say aye. Wait, I'm sorry, 581. 581, say aye. Those opposed, no. The ayes have it. You move out to civil.
Thank you, Madam Chair and Committee. And I appreciate your indulgence. Everybody knows what this time of year is like.
We're going to move back to item number 9, House Bill 1292 by Representative Johnson. Properly motioned and second, you're recognized.
Thank you, Madam Chair and members. I do have an amendment It's 5417. And that changes, takes away part of the language. There was a category of intimate partner, and some of the people that were in opposition to the bill had a problem with that. So we wanted to make sure that this applies to people who are very close to the respondent in this situation. And we changed that. And then we also, because these folks are a danger to themselves or others, we made it immediate instead of a 48-hour period before removing firearms.
Okay, the amendment is properly motioned and second. All those in favor of Amendment 5417 going on to House Bill 1292, say aye. Aye. Those opposed, no. The ayes have it. So you are back on 1292 as amended.
Right. So this bill is a temporary method to remove firearms from somebody who is having a temporary situation. They're a danger to themselves or others. And we want to keep it really specifically close to close members of the family and people who know the respondent well, or perhaps law enforcement who have know the respondent through situations with law enforcement. But what it does is it creates a temporary way to remove weapons. Like if you have someone declared, incompetent or anything like that, that's a permanent loss of their firearms. And this allows up to 1 year for someone who is in a situation where they might be in danger to themselves or others. These orders, typically what we see, there's 19 states that have enacted these orders now, and typically what we see is, it's not combative with the judge. It's families that, that understand they're doing this for your safety. A lot of people are concerned somebody's trying to take away my weapons who has a grudge or something like that. If you file a petition based on something that's not legitimate, they have the ability to press charges on that person who does that without having a real reason. So there's protections in there for that. Also, for the respondent, they can come back in front of the judge anytime, as many times as they want in that year. So say we're in a situation where someone's really depressed because they lost a family member, or a divorce, some situation like that. Family's concerned because they have the guns in the house. And, whether it's just getting through that process, working with mental health, maybe getting on some medication, then they can come back and say, he's got it together. We all feel comfortable that those guns, or he or she can have those guns back. And so it's just, it's safekeeping. And what we found in states that have passed these laws is that we've seen suicide reduction from anywhere from 8 to 14% so far, and that's not in a whole lot of time. We're not seeing these overused. They're pretty infrequent, but typically, like I say, it's not a combative situation, and it's all about keeping people safe. So that's what the bill does, and I'm happy to answer questions if you have them.
Representative Gillespie, you're recognized.
Thank you, Madam Chair. Sponsor, thanks for bringing this. I certainly agree with the overall point that you're trying to make. I do have a couple of issues here that I just want to address. The household member, past household members, family members, past family members. I think this could be really abused very, very quickly, and I just want to go ahead. I don't necessarily need a response. I just want to put that on the record.
Are there any other questions?
Could I speak to that? Thank you. Yeah, and I do understand that we had a situation in near my home where we had a couple who had divorced, and so the ex-wife, they had a child that was, custody in both places. Child was back and forth between the homes. The ex-wife knew that the husband had a gun, and horribly enough, he used the gun to kill their son. You know, some people stress, I don't really understand it, their stress and depression didn't act inwardly on himself, but outwardly on that child. And with this, even though she's not still living with him, she has close knowledge of where he is. And he had actually had surgery and had been taking opiates for pain after the surgery. So, you know, and she was able to be aware of that. So it's situations like that that sometimes make that necessary.
Representative Brickham.
Thank you, Chair Lady, and for the sponsor. Again, this bill, I'm probably, I'm probably not going to be able to support it, but primarily because I think it causes a chance for situations to get escalated more when you request law enforcement to remove a weapon in anyone's household. And I think you're going to create greater danger and greater cause of harm by having this vehicle than not doing anything. I think certainly families and friends have always been, I'm going to say, obligated or tried to guard against harm for anybody, and I think have been hopefully somewhat successful. I'm sure it's not perfect, but I'm afraid this will cause more escalated violence than less. So, therefore, I will not be able to support the bill.
And I would like to say I do understand that to some degree, but that's not what's shown in the data and research of the states that have passed it. The opposite has been shown to be true, but certainly, you know, I can imagine that might happen in some instances. But that's just not what we're seeing in the states that have passed it.
Any other questions? Seeing none, are we ready to vote? Representative Stewart.
My question is, it looks like this bill could have been used to prevent, not with that particular family, but prevent the Waffle House killing here in Nashville, where you had a mentally ill, I believe mentally ill person shoot people in the Waffle House, as well as the attack in my district on the church in Antioch that was attacked by a person who, if I recall news accounts, was known to his family to be troubled. I'm not going to speak in terms of a technical matter of a mental illness. Is that correct?
Yes, that's exactly the type of incidents that we're talking about. As a matter of fact, you know, those parents did try to do something and were not able to because we didn't have this in place. And even if you look at Parkland, where law enforcement were aware with some issues of the young man, they weren't necessarily able to do anything, and this would give folks some recourse in those type of situations. But what they're finding really where it makes the difference more than anything probably is suicides.
Representative Stewart.
Yeah, and am I right that I was reading an article about this, because a judge is involved, right, there's really not, I mean, as long as the courts are functioning properly, which in our state they are, there's really not an issue of somebody's rights being impaired in any meaningful way, right? Because my understanding of the way your bill works, if somebody is perfectly sane and somebody, for wrong reasons, tries to implement this statute, the judge, there's an immediate right to go to a judge and get it lifted. So someone could literally walk into court and say, this is nonsense, right? Isn't that the safeguard to make sure that there's due process here so nobody loses a right without a hearing?
Yes, absolutely. There are safeguards throughout. And like I said, the ability for the respondent to come forward anytime if, they're no longer in danger and that sort of thing. So it is the judge. And, you don't have to have attorneys, that sort of thing. It's just letting that judge make that decision based on the information from the parties present.
Representative Stewart.
Yeah, and final question, thanks to members of the committee. I was reading about Oregon, which had one of the earliest statutes, and it sounds like in most cases, you mentioned suicide, Most of the times when this law in Oregon has been implemented, it's been implemented by family members, usually trying to save their children from suicide. Is that right? I mean, it sounds like this is usually a family affair where this sort of bill is implicated.
Yeah, that's correct. Well, that's what we found and like I said, in the courtroom, it's typically not combative. It's family knowing that they're trying to keep each other safe, knowing that they've got someone who is really more of a danger to themselves. And so, as I said, that's why we're really seeing a number of decreases in those states that have passed this law in suicides, because typically, you know, when a gun is used to commit suicide, there's usually, I hate the word success, but.
Any other questions? Hearing none, are we ready? Vice Chair Eldridge.
Just I guess, a quick question. You mentioned the father that killed his son. Had police been involved? Had they been called to the house? Were there other problems there, or?
Not to my knowledge. There was not as much press on that incident as others, but to my knowledge, there was not. Of course, the mom knew. She was very concerned about leaving her child there, but she really didn't think her child was in danger. She thought her ex-husband was in danger. You know, I can't imagine the regrets you have in that situation, but.
I guess, you know, in most cases, I think where these situations come up, usually law enforcement has been involved before for a while. And you know, I think there should be a mechanism where if someone, the family, like the lady, knew that she, you know, there was a problem there, did she try to reach out to law enforcement prior to that? I mean, even whether her concern was about the son or the ex-husband, either one, had she tried to reach out to anybody, talk to anyone about, you know, maybe his mental health condition, or?
She did try to reach out to the courts to see what she could do about not having her son go with him for a time.
Okay. Thank you. Thank you.
Representative Brickham.
Just another quick question. Is there anywhere in the legislation that would prevent if let's say the father, in your example, if this was implemented and law enforcement went and removed his weapon, prevent him from going out the next day and buying another weapon?
Yes, there is. They cannot have or purchase another weapon in this time that the ERPO is in effect.
How would that get implemented? I mean, again, I don't know how quick the background check information in the system is updated, but I've not heard. So, I mean, once that order was issued, it would have to be immediate on the system. So I don't, again, you know anything about how the speed of that works?
No.
You're recognized.
Sorry. I do not, but it's my understanding that it will go in, like everything else, it will go in the system. And it does talk about if they violate that by purchasing another gun, and it is discussed in the bill.
Again, someone,
Representative
excuse me.
Brooklyn.
Thank you, Mr. Chairman. I think someone goes down that route, they're not paying much attention to law and order anyway, so anyway, that's all the comment.
Any more questions? Any objection to the question? Ready to vote? All those in favor of House Bill 1292, say aye. Aye. Those opposed, say no. No. The noes have it. Sorry. The bill fails.
Thank you, Madam Chair and members.
Are there any more announcements? Do I hear a motion for adjournment? We are adjourned.